I'm Chris Coons.
Kristina Crump. We're both bankruptcy attorneys here in Kansas and Western District of Missouri. Today we're going to talk about top 5 myths about bankruptcy.
So I think myth number 1, you're going to lose everything. You're going to lose your car, you're going to lose your home, you're going to lose your personal property. They're going to pull up with moving vans and take everything. And nothing could be further from the truth. You have exemptions in bankruptcy that protect your personal property. In cases where you do have some property that might not be exempt, you and your attorney can sit down and plan out how to deal with that so that you'll be able to retain that property. And that may determine what kind of bankruptcy you file. But in general, people are not going to lose their basic necessities and the things that they need to live and go to work.
Number 2, you will not be able to recover your credit rating or your credit score in this lifetime. Well, that is totally false. A lot of times by the time people come to our office, their credit score is already pretty low, usually in 500s, maybe low 600s. So the fact that you file bankruptcy is probably not going to matter much in terms of your actual credit score. Now, the fact that you do file bankruptcy is going to stay on your credit report. It's for 7 years if you're in a Chapter 13 and 10 years if you're in a Chapter 7. But in our experience, once you completed the bankruptcy case, you will have access to credit. At the beginning, it might be a little bit more expensive, but it's not like nobody is going to ever loan you the money again. And a lot of times, if you do not have any new collection activities, if you're keeping an eye on your credit score, if you're correcting the errors, you should be able to see that credit score go up relatively quickly, even within a couple years of filing of the case.
Number 3, you're going to lose your job if you file a bankruptcy. Well, there is actually a federal law that protects you from this kind of behavior by employers. So you cannot be fired for having filed bankruptcy. And it is a question that we often get asked by folks that have positions where they think the employer is going to be especially interested in their financial issues. And I've certainly never had a client lose their job because of filing a bankruptcy. But more importantly, there is actually a federal protective law that prevents this from happening.
Number 4, debt settlement is more effective than a bankruptcy. Now, there are other things that you can do besides bankruptcy to deal with your debt. And sometimes that makes sense. A lot of times, though, people do not have enough money coming in the door, or the debt load is so overwhelming that there's just not a possible way to pay off that debt within the next couple years. And what you're looking at is potentially being in those programs for 10, 15, years or longer. Also, a lot of times, debt settlements, debt management programs do not protect you against lawsuits. So a lot of times you're really taking a chance on working with those programs, and only a bankruptcy can prevent an actual lawsuit where a creditor takes you to court and obtains a garnishment against you. So can debt management programs work? Absolutely, and debt settlement programs can work as well. But please consult a bankruptcy attorney who can actually explain you all options that you have, including your options in bankruptcy and how that will affect your financial life.
Number 5, I can pick and choose which creditors to list in my case. You are supposed to list all of your creditors when you file a bankruptcy case. So you may have a favorite bank, or you may have a favorite business that you work with and that you want to try and maintain a relationship with. But you have an obligation to list them in your case. You don't get to leave them out. So you're going to have to put them in the case. It's extremely important to understand that that doesn't mean that you cannot pay them after the case is done. So there are plenty of times where people want to continue the business relationship they have with a creditor, and they'll list them in the case, and then they'll go to them after the case and say, well, I still want to do business with you. Sometimes that means doing what we call a reaffirmation agreement. But sometimes it just means going to the creditor after the discharge in the case and saying, listen, I still want to work with you. I still want to pay you. This comes up sometimes with private physicians or dentists or people like that, where you really want to maintain a very personal relationship that you have. So you're going to end up paying that obligation anyway.
So just to summarize, you're not going to lose your car, home, and personal property.
Yeah, you're going to be able to recover your credit, and it's probably going to be pretty quickly.
You're not going to lose your job.
Yeah, debt settlements and sometimes debt managements are probably not as effective as a bankruptcy case.
And no, you cannot pick and choose creditors to list, but there are ways to work around that.
Yeah, I think that pretty much sums it up. If you have any questions about bankruptcy, please give us a call. If you need to stop creditor calls, harassment, collections, lawsuits, repossessions, garnishments, or foreclosures, please give us a call. Consultations are free.